Hi, today is Tuesday, December 14th. I talked to a senior citizen yesterday, a client of HELP's, about an interesting issue that I thought I would address today. And that is the question, can the bank where you bank, where your Social Security is deposited, take money from your account to pay a debt that you owe the bank, a loan that you owe the bank, a credit card or other loan that might be in default, when the only income that goes into that account is Social Security? The short answer, with a few exceptions, is no, they can't. There might be an exception, but not too many, very few. And I'll tell you how this question came up. Yesterday, got a call from a gentleman, and he was upset because his bank account had been garnished. And first off, I explained to him. I said, "Well, that's not supposed to happen. Twice the amount of your Social Security is automatically protected in that account, no matter what monies are in there." And I knew that he got around $1,500 in Social Security. And how much was in your bank account? And he said $500. And he said they've taken the money. And so I knew I needed to ask a couple of follow-up questions. I said, "Well, how many bank accounts do you have?" Well, he said, "I have two bank accounts. I have a savings account and a checking account." "Well, where does your Social Security go?" "It goes into my checking account." "Well, how much was in your savings account?" He said $50. So I told him, I said, "Well, I think they can take the $50, okay, but you can probably get it back by filing a challenge or garnishment claim of exemption. But the $450, the balance of your money in your checking account, where your Social Security goes, that should be released by the bank. If it isn't already, it will happen shortly." The federal rule tells the banks they have 48 hours to examine the account to determine where the money came from that went into the account. Went into your bank account. And there's a code on the deposit, and they can identify if it came from Social Security or a federal pension or some VA benefit or some federal source. And the rule tells the bank that they have to times that, sometimes two, and that amount is protected regardless of the source of funds actually in the account at the time. So I said, no, that shouldn't happen. But then I asked him a couple of follow-up questions, and I said, "Well, who do you think did this?" And he said, "Well, my bank did it." And I said, "Well, do you owe money to your bank?" And he said, "Yeah, I've owed them money for years." I said, "What for?" And he says, "Well, a credit card." And so I thought, well, did the bank take the money from his account because he owed money to the bank for that credit card debt? I didn't think they did, because there's another federal rule that instructs banks that they cannot do a set-off of money in a person's account that comes from Social Security to pay a debt that's owed to the bank, unless they've received explicit permission from the person that they can do that. And and they normally don't. People don't, unless you give the bank authority to take money out each month. But if you're in default on a credit card, the forms that you signed for the credit card didn't give the bank permission to take money out of your account to pay that. Their forms don't say that for a bank. So I immediately knew that wasn't going to be the issue. But that's the issue I want to talk about, and I want to make clear. If you owe money to your bank and you're behind on the payment and you're in default and you still bank with that bank, which isn't unusual. Banks don't kick people out if you don't pay the debt. That's not their normal practice. The bank, under federal regulations, will not take money out of your account to pay that past due debt. They don't do it. But in his case, it was unusual in that there was a writ of the bank had sued him earlier, and there was a writ of garnishment filed against him, and which meant that twice the amount of that money was automatically protected under that different rule that has to do with judgments and garnishments. So there's a difference between a garnishment of an account by someone else, someone who has a judgment against you, and where you owe your own bank and they can take money out of your account, okay, if you owe them money. Now, a bank can legally take money out of your account for bank fees or bank charges or NSF charges. They can do that. They're allowed to do that. So if you have an NSF check, they can take money out. Or if someone took advantage of it and you wrote a check that from your account that went to a scammer or something like that, it's not the bank's fault that that happened. And that, in fact, you're the one who wrote the check and someone took advantage of you. So in that instance, the bank could take money out of your account. So the bank can take money out of the account for bank charges, NSF charges, or monies that they pay on your behalf from your account, but they can't take money out of your account into which Social Security goes to pay a debt that you owe the bank for a loan or a credit card that's owed to the bank. Now, it's different with credit unions. I used to tell people for many years when I was doing a lot of bankruptcies, many thousands of bankruptcies, that credit unions subscribe to the same stationery store. They all have the same form, okay? And that form says that, it says a lot of things, but one of the things that the form says is that you give the credit union authority to take money out of your account to pay any debt you owe them, no matter where the money came from that's in your account. So a credit union will take money out of your account if you're in default, if your only income is Social Security, to pay a debt that they're owed. They will do that. And so they'll also terminate you from the credit union if you owe a debt and you don't pay it. So when people come to us and they owe money to their credit union that they're not going to be able to pay, I tell them, well, you need to get a different bank account with a different organization. And the sooner you do that, the better. Otherwise, you're either going to get kicked out of the credit union or they're going to take money out of your account for the money you owe them. Now, they're not going to do that automatically if you miss a payment or two payments or maybe three payments or maybe even four payments. They eventually will do it. So, I mean, you can take time to change to a different bank or a different bank account. That's what I want to explain today, that there's a difference between having your account garnished by someone who has a judgment against you and having money taken from your account if you owe money to your bank or credit union. Banks won't do it. Credit unions will. Now, the rule is that the bank could take money out of your account if other money's going to the account. Like if you had a pension or disability or some other money, they could theoretically and legally take money out of your account to pay the debt. They could do that. But as a practice, they normally don't. Okay, so if you have a bank account and it's very convenient for you and you have a debt that you're not able to pay, it's very unlikely the bank's going to do a set-off of money in your account to pay that debt. If it's other than Social Security, legally they could do that, but as a practical matter, they probably aren't going to do that. So that's my message for today. My name is Eric Olson. I'm the Director of HELPS. We're a law firm that represents seniors and disabled persons in all 50 states. Social Security is protected. So is almost all retirement funds. It doesn't need to be used to pay debt you can't afford to pay. And under federal law, when a person is represented by an attorney, debt collectors can no longer call or send letters to that person anymore. And that's what we do, is we represent seniors and disabled persons who have debt they can't afford to pay in order to stop debt collector harassment. People call us, we enroll them in the program, they give us the people they owe money to, we send what's called a cease and desist letter, and the collector has to leave the senior or disabled person alone. They have to deal with us, not them anymore. And our second mission is to educate seniors how they can maintain their financial independence. We don't turn anyone away that needs our help. You can learn more about us by visiting our website at www.helpsishere.org. HELPSIS here, HERE.org. HELP stands for Help Eliminate Legal Problems for Seniors. And you can also call us toll free at 855-HELPS, HELPS, US, or Helps Us, either one. Helps US, and we'll talk to you, answer your questions, and if you need our help, we'll be glad to help you. And you have a great day.